Okay, we will begin. Good morning, everyone. Thank you for joining us. My name is Sharon Kidman. I am the Bureau of Indian Affairs, Central Office, Office of Trust Services, Division of Real Estate Services, National HEARTH Act Coordinator. Today for the presentation, I will also have on the line Ms. Suzanne Nunn from the Office of the Solicitor, Washington, D.C. Uh, I will be covering the 52 IAM 13 policy today for the tribes, and Suzanne will be covering the legal sufficiency checklist. Again, we thank you for joining us today. And if you have any questions, we ask that you put them in the chat and we will get to them at the end of the presentations. So to begin with this morning, on the screen, you can see the HEARTH Act website. In the chat, I did put the link to the website because the materials provided for today's training are right here on the website. So if you scroll all the way down, the first thing we are going to be looking at is the 52 IAM 13 policy, which is right here. I'm going to click on that so we can go ahead and begin to go over the pages for today. In the beginning, we have the purpose, the scope, and the policy and the authority, but those you can read at your own convenience. I'm going to go ahead. It covers responsibilities, some definitions, and I'm going to go ahead and skip to page 5 because it begins the process here. So today, with our tribal partners online, um, we are covering how does a tribe begin what do they need to do to start their HEARTH Act regulations or begin drafting them. They begin by drafting them first and approving them, but how do they submit them? Right here in the policy, it has a line for line item, but I will only cover pertinent ones for now because you guys can read the entire policy at your convenience at a later time. But right now, for part 1, we're going to cover submission. Under 1A, it says the original, we're going to need a couple of things. A, B, cover those items, and I'm going to read those ones out verbatim because it's very important. A is an original cover letter that includes 1, a request for review and approval of the regulations under the HEARTH Act. 2, the contact information for parties with decision-making authority regarding the regulations. For example, tribal officers, legal counsel. And 3, any special circumstances regarding submission of the regulations, like an urgent need for an approval, a unique provision included in the regulations, etc. So number 1, the cover letter should cover those things. Under letter 1B, it says we need 1 original of the regulations approved by the tribe and signed by the authorized tribal parties, and a tribal resolution authorizing the regulations, and it must be an original and not a copy. And then the second sentence just kind of goes into what happens if it's not an original and we send it back. Letter C has the mailing address to which you will be mailing it to. Do not give it to your regional offices. Do not give it to the agency. All packages must be mailed to the attention of the division chief for Division of Real Estate Services. And you could just simply put on the letter, attention division chief, because people come and go from their offices. So we would prefer that instead of saying, here's Dear Jane Doe, just put simply attention division chief, Division of Real Estate Services. Okay. On letter D, it says the HAC, which is my short title, HEARTH Act Coordinator, will request the tribe to email a PDF and Word version of the submission to myself. So when the tribe gets ready to submit, those folks who are going to be mailing it should already have a PDF version of what they're going to mail, of the originals, and they will email them to me along with the Word document version of the leasing ordinance itself. That way we have it, and once the package is received at central office, we can just go ahead and get going on the review. So letter D is very important to remember that If you are mailing it, please be sure to concurrently email me a PDF copy of the originals along with sending me the Word document version of the leasing ordinance. Scrolling down, this section covers step by step what happens when I receive it and how it goes through what we do on our end. So at your convenience, feel free to read through these steps because it is literally a step-by-step process of what happens with the files once we receive them, the submission. I'm going to go ahead and scroll down to B, which is the initial review. So myself, COSOL stands for Central Office of the Solicitors. So the Office of the Solicitor is also a short name for SOL. So you'll hear me refer to that throughout the training. Myself, the Office of the Solicitor, and the Regional Realty Office, that is what our RO stands for, we will review and make comments to the Word document that I will give to them. And per the policy, as you can see right here on number 2, we have 30 days from the time it is date stamped to review the tribe's regulations. If it goes outside of that 30 days, I will contact the tribal POCs listed on the cover letter and notify them that the Bureau will need an extra 5 days over the 30 days because something might have happened, a priority might have come in from Asia and we needed to do that. And so it kind of interrupted our review time. So that rarely happens, but just so you know, we do contact the tribal POCs and let them know. But for the most part, we do stick within the 30-day time frame. After that time frame, I'm going to jump to number 4 right here. We have an additional 15 days to the 30. So it's 45 total to have an internal call with ourselves, the Central Office Division of Real Estate Services, Central Office, and Regional Realty Office. The 3 of us will meet and we will discuss our own comments that we make prior to sending it to the tribal POC listed in the letter. So that's an important note to remember because I do get emails saying, where are we at? How long are we doing? So I always give the tribal POCs listed in the letter, I always give them a copy of the policy right off the bat because the policy is the guideline. It tells you what step we're at, where are we going, how many days, who has what. So it's very important to just kind of keep this as a guidance tool for yourselves on your desktop somewhere. So after the 15 days, let's jump down to number 5. As soon as our call is completed, I immediately within either the same day or the next day, but it's usually I try to make it immediate. I send those regulations back to the tribe with our comments, and I request in number 5 a conference call with them, which we call an external call. So we have 10 days to schedule that call with them. So when we send those regulations back to the tribe, we go ahead and give them 2 potential dates that we can have this call. And if one of those dates don't work, then we go back again to the calendar and look at dates that the tribe is available to have a conference call with us. After the call is done, further down right here, they have a time frame to submit or modify their comments and to get them back to us so that we can review it for them again and we can move the process to an eventual final leasing ordinance. So I won't read these out verbatim, like I said, but as you can see here, at the end of 30 days, right at the bottom here, that the HEARTH Act coordinator will provide a recommendation to Asia via DTS to approve or disapprove. DTS is the short name for the data tracking system. That is where all our mail moves through that system. But it just gives you a step-by-step of what we do at the beginning. So scrolling down to letter C, which is modified submission of leasing regs, this is what happens step by step. when we have tribes submit modified versions of what we do when we go through these calls with them. Usually there is only one call with the tribe. After that, if the tribe feels they need another call, they just simply let us know and we will schedule a second call in case they need further clarification from the first call. And that is what is the steps that are laid out here in the modified leasing regulations section. We also have the section for failure to resubmit modified leasing regulations. And we put this in here just so the tribes are aware that there are steps to take in the event a tribe, let's say, changes their mind and say, okay, you know what, we haven't had, as a tribe, we haven't had enough time to discuss this. We would like to discuss internally more, and we will let you know if we will resubmit. We've had this happen, and that is perfectly fine. And these tribes have come back later on and have resubmitted their package. But right here is the steps where it talks about submitting failure to resubmit. Sometimes the tribe will withdraw, and that is also laid out in here. It's a very simple process. The tribe will write a letter and they will send it to me and the division chief, and letting us know that they would like to cancel their submission and reapply at a later time. Scrolling down, letter E is the final submission, this section right here. In the final submission, just like you had the initial submission, we have a final one. So once we have gone through the internal review process, we will reach what's called a final leasing ordinance, an agreed upon final leasing ordinance. After that, I will ask the tribe in number 1 to again submit an original of the final leasing regs, a tribal resolution authorizing those modifications, and a cover letter indicating their request to expedite the approval process for the surnaming and approval part. So steps 1, 2, 3, and 4 on section E, final submission, are the steps that we take for that part. Scrolling down to letter F, the approval part right here. On this part, once I receive those documents in the mail, the final submission, I draft these documents covered in letter, number 1. I will draft these documents. I prepare them and I draft them for Asia to review and approve. So these will get uploaded into our what's called the data tracking system. And that's where the case will go, because once it leaves the Division of Real Estate Services hands, DRES, once it leaves our hands, it goes to the other divisions, RACA, Asia's counselors, ESIA, which is the Executive Secretary's office for the Secretary. It goes through these other offices for surnaming and approval. And then it goes back to RACA. It will go to SIO regs, which is the regulatory committee. They must review it. Their standard time frame is 30 days. It's up to 30 days, but they have done very well in getting it down to about 10 days. But for the most part, we tell you 30 days because we don't know, what goes on in their offices and their priorities. So they get 30 days to review it, the regulatory committee. But like I said, it's been in about a 10-day range. They give it back to RACA. RACA then will prepare it for posting and publishing. And once that happens, I then prepare a letter for the Director, Bureau of Indian Affairs to sign. Once that letter is signed, it is uploaded. Our office is notified. I will then draw that letter off the system, and I will send the copy of the approved regulations and a copy of the Federal Register notice to the tribes when the process has completed. Now, my notification goes only to the tribal leader and those tribal POCs listed in the tribal leaders letter. So I do not send it to all and sundry because I'm not allowed to. So it is only to those people listed in the tribal leaders letter. After that, that is, I think, yep, I'm done with that section. So Once the approval is done, like I said, all of that part is done, the tribe is notified. The case is then closed out in the data tracking system, and the tribe is then free to move on with their leasing authority. At this point, I'm going to go ahead and turn the mic over to Ms. Suzanne Nunn from the Office of the Solicitor for the next part of the presentation. Suzanne?
Thanks, Sharon. I'll share my screen real quick. 1 second. Okay. Hopefully you guys can see the screen. What I'm going to do is just go over our legal sufficiency checklist. This is what we do at the solicitor's office when we receive a tribe's draft HEARTH Act regulations. Those regulations have to be consistent with the 25 CFR 162 leasing regulations. And so I've created a checklist to make sure that the tribe submission are in compliance with the 162s. Now, they don't need to be, the tribe's HEARTH Act leasing regulations don't need to be verbatim to the 162 regs, but they do need to be consistent with them. So we understand that each tribal community is different from each other, and all, each community has their own little idiosyncrasies, so to speak, that the tribe's laws need to take into consideration when the tribe is drafting those laws. So we are very aware of that. And so we have, there's flexibility, I guess is what I'm trying to say, within the tribe's leasing regulations. But, we try to give that flexibility as much as we can, but they still need to be consistent with 162 regs. So what we look for when we do our legal sufficiency checklist is this checklist will show the mandatory provisions, the provisions that need to be in the tribe's HEARTH Act leasing regulations. Now, when we do our review, we do not redline tribes leasing regulations. We only add comments. We'll highlight a section and we'll add a comment. And so our comments will be in usually 3 different categories. We will have required, which are the mandatory provisions. They've got to be in the tribe's leasing regulations. There's no ifs, ands, or buts about it. They've got to be in there. And so there's mandatory, so that's required. The next category that we put, that our comments fall under, is strongly recommended. David Moran, who works with me for the time being in solicitor's office, so David was in on the original writing of the HEARTH Act itself, of the statute itself. And so he helps with the review. He does the review as well. So what we look at when we look at our HEARTH Act, the tribal HEARTH Act submissions, we look for specific definitions. There are some definitions that are mandatory and required, and there are some definitions that are just strongly recommended, such as the best interest of the tribe is not a mandatory definition, but through our years of reviewing the tribe's HEARTH Act codes, we found that this definition helps the tribe have the flexibility that it needs to make their own tribal decisions without having to. So the tribe, the best interest of the tribe definition will allow the tribe to have the flexibility to make decisions without, through a kind of a transparent process. So we strongly recommend it. We use it for things such as the rental compensation, so that the tribe, if the tribe is doing a residential project, maybe a housing project or something, the tribe can determine what that rental compensation will be. That is in the best interest of the tribe. So if the tribe wants to make the rental compensation, nominal, the tribe can do that. It doesn't have to be fair market rental value. The other decisions that a lot of tribes use this definition for are whether or not to require a bond, a performance bond, whether or not to require insurance, things like that. So we strongly recommend this decision, but it's not mandatory. As you can see on this checklist, there are notes where the definition is not mandatory. If you don't see this note that says not required, then it is mandatory and it is required. The lessor can only be the tribe, cannot be any other entity than the tribe, because the statute is very clear that the tribe is the approver, the ultimate the only one that the HEARTH Act applies to. So I guess what I mean by that is that this in obtaining the approved HEARTH Act regulations, the secretary, once approved, the secretary basically delegates his or her authority to the tribal council or to the tribe to approve those leases. So the tribe basically steps into the shoes of the secretary. Because of that, the tribe can only be the lessor. Only the tribe can be the lessor. Another definition that we have to be very careful of is the public for purposes of environmental review. Now, this definition, we like to keep the term for purposes of environmental review because it narrows the realm of who the public is. So the public, when writing the HEARTH Act statute, Congress was very, very clear that the environmental review, the environmental impacts had to be made known to the public, a larger audience than just the tribe's membership. It has to extend beyond the tribe's boundaries. Congress was very clear about that. And Congress was very clear about the fact that there has to be, the tribe has to, if the tribe finds significant impacts on the environment, they have got to give public notice and allow the public to comment on these on the activity, on the lease activity that is causing the effects on the environment. And then the tribe has got to respond to those relevant and substantive comments. Now, the tribe is in the position of determining what is a relevant and substantive comment. The tribe determines what they think is something that is a comment that they need to respond to. We don't tell you what is a substantive or relevant comment. So there's flexibility that way. And also the environmental review, the reason Congress is so clear on the environmental portion is because it did not require a NEPA review. A NEPA review is extremely stringent, and you've got to go through a lot of hoops, as most of you know. And so the HEARTH Act is not as stringent of a environmental review process. And because of that, there are guardrails that have got to be included in each tribe's HEARTH Act regulations. Again, public, for the purposes of environmental review, has to be somebody who can demonstrate that they will be directly, substantially affected by the lease or the lease activity. It cannot be as narrow as just the members of the community. In addition, we don't generally, there are a few tribal HEARTH Act codes that have like a distance boundary, say public is everybody who is within a mile of the leased premises. We don't really, uh, I guess what's the word I'm looking for? We try to stay away from that kind of a limitation with regards to the proximity, I guess, of the lease activity. So the next things that we look for that have got to be in the Tribes Hearth Act regulations are a provision that gives the tribe the authority to enact these regulations, such as a constitution, tribal constitution, or tribal bylaws. Now, we understand that there are pueblos and some tribes out there that don't have tribal constitutions, and that's fine. We work with the tribes to come up with, or for the tribes to cite to whatever the authority is that they have to enact their own laws and be ruled by them. So, we also, you have to, the regulations also have to say that the Hearth Act leases only, these regulations only apply to 100% tribal trust land. These regulations cannot be used. You cannot use a Hearth Act lease for an allotment for any kind of land that the tribe only owns a portion of. The Hearth Act only applies to 100% tribal trust land. And again, that goes back to the secretarial delegation authority that the secretary gives to the tribe to enter into and approve these leases. So the Hearth Act doesn't apply to fee lands, it doesn't apply to mineral interests, and that has to be, those all have to be within the tribe's Hearth Act regulations. They also have to state what types of leases these regulations encompass. Is it a comprehensive regulation that includes agriculture, residential business, wind energy, wind solar, or is it just residential, or is it just business? So the Tribal Hearth Act code has to have a provision that addresses that. Also has to have a provision that addresses what laws are applicable to these leases. We do not apply state law. State law does not apply in a Tribal Hearth Act. And so we do not let tribes apply state law unless there's some situation, say arbitration or mediation, that the tribe wants to apply state law. Excuse me, that we will talk with the tribe about that. And if we find that it is limited, state law is limited to the arbitration or something, then it might be okay. Excuse me. The tribe has to have a provision in there that states that any minor technical amendments to this Hearth Act regulation, once it's approved, can be approved by the tribal council, but any major substantive amendments have got to come back through the secretary for review and approval. So each lease has to have required contractual provisions, right? So, and these provisions have got to be spelled out in the tribe's Hearth Act regulations. You've got your typical contractual provisions, parties to the lease, the purpose of the lease, the effective date, the term, and I'll note that it has to identify the tract or the leased premises in a manner that's sufficient for LTRO to identify them. So it's really important. BIA and the secretary, BIA, once the tribe has their approved Hearth Act regulations, the BIA doesn't review those leases that are submitted to LTRO for recordation. They will look at some things to make sure that some things are in line, but it's not an in-depth review as the BIA will do under 162, under a 162 lease. So we've got to make sure that the parcel, the lease premises, is identified so LTRO can record it, because everything has to be recorded by LTRO one way or the other. So, again, the contractual terms, if there is a renewal period for the leases, say for instance, I don't know, a business lease is 25 years, and then the lease has two 25-year options to renew. Anytime a lease has options to renew, it's got to specify the time and manner the option must be exercised, or if the option is automatically effective. It's got to identify any additional consideration that will be due upon the exercise of that option. And so all of this has to be in the tribe's HEARTH Act regulations. I will note that a wind energy evaluation lease is 3 years with one 3-year option to renew. However, if expressly stated in the lease, a wheel can convert at the end of that 3 years or at any time within that 3 years to a WSR, which is a wind solar resource lease. And that then you can extend that lease to the 25 years with two 25-year options to renew. Again, any lease amendment, assignment, renewal, or leasehold mortgage must be recorded at LTRO. So that has to be in the, that provision has got to be in the tribe's HEARTH Act regulations. There've got to be payment provisions in the tribe's HEARTH Act regulations. It got to provide for the payment of rent. If it's in the best interest, it can be whatever the tribe feels it wants to provide. It's got to have the dates the payments are due, whom the payments are made. If the lease allows for the payments to be made directly to the tribe has got to maintain documentation of those payments that are sufficient to enable the secretary to discharge the trust responsibility. So in other words, secretary is not responsible for keeping track of those lease payments. The tribe is. And the leases and the tribe's regulations have got to state whether there's going to be a rental review or adjustment period, how those are made, who makes them, and when they're effective, and how any dispute about the adjustments are resolved. And so on the leasing regulations, if the tribe determines that they'd like to allow the lessee to assign or sublease or have a leasehold mortgage, the leasing regulations, the tribe's HEARTH Act regulations have to have provisions addressing that. Now, you can allow for the mortgage of a leasehold estate interest, but you cannot allow for mortgages of trust land. So you've got to keep it specific to the leasehold interest of the lessee, and not the land itself. So that mortgage would be just on the permanent improvement on the property. And I'm not going to go through each one of these. But I will state that there has to be provisions allowing the lessee some kind of recourse if there's if the tribe finds a violation or a breach of contract by the lessee. That lessee has got to have some kind of recourse. There are rights that they have to have. So there has to be those provisions in each tribe's HEARTH Act regulations. It cannot be the tribe's, in the tribe's HEARTH Act regulations, and this goes for all kinds of other things as well, but you cannot just cross-reference other tribal regulations. Now, a lot of tribes say, okay, they have a provision in their HEARTH Act regulations that say, for instance, lease enforcement will be pursuant to XYZ's tribe's housing ordinance. If the tribe does that in their HEARTH Act regulations, the problem is that the tribe then has to submit the housing ordinance for us to review and approve to make sure that it complies with the 162 regulations and the HEARTH Act statute itself. We would really rather not do that. We don't like to review other ordinances, other tribes' ordinances. That's kind of it's just not something that we find is a good practice. So what we tell tribes is, if you have provisions in your housing ordinance that are enforcement provisions of a lease, just cut and paste those provisions into your Hearth Act code. So we could just look at the specific provisions that apply to your Hearth Act leases. Same thing for environmental section. Most tribes have their own environmental regulations. They have their own environmental review, a TERO, a tribal environmental review ordinance. And that's great, but you can't cite your TERO into your tribe's Hearth Act regulations and just say environmental review process will be pursuant to our TERO. You've got to cut and paste those provisions into your tribal Hearth Act code. And it's just something that has to be done. And so I just wanted to point that out, because we've had a few instances where tribes do this and don't understand that you really can't cross-reference. The other thing I'd like to say about cross-referencing is, do not cross-reference 162 leasing regulations, please. Once this Tribal Hearth Act code is approved by the secretary, that is the controlling law of the Hearth Act leases, not 162. So when the tribe is writing their Hearth Act regulations and they refer to 162, that's an inaccurate reference, because again, the controlling law is not 162 at that point. The controlling law is the tribe's Hearth Act regulations, right? So we don't like to cross-reference the 162 regulations. We will point that out and have the tribe remove those before approval. And I'd also like to point out, and I'm sure Sharon has pointed out, that even though a tribe has these Hearth Act regulations approved by the secretary, there is still the option to have a lease go through the 162 process. It's not an either 162 or Hearth Act for the tribe. The tribe can elect to go through the 162 process on specific leases if they'd like to. So I think that that's something that needs to be pointed out. But once a lease has begun and is executed under the Hearth Act, it has got to stay under the Hearth Act. There's no grandfathering. Once a lease is a 162 lease, it's got to remain for the duration a 162 lease. And so if it's a 162 lease, you cannot have the tribe's council approve that lease. It's got to go through the secretarial approval process. And so this tribal checklist has everything that is, again, mandatory. There are notes here that say it must be it can be waived if it's in the best interest. I am happy to supply a copy of these this checklist to anybody who would like them. Also, they are on the Hearth Act webpage, and you can go in and download them and use them in drafting your tribal Hearth Act codes. I think that's all I have. And if anybody has any questions, please feel free to put them in the chat, or I will put my email address in the chat, and please feel free to contact me or David Moran if you have any questions. Thanks very much, everybody.
Thank you, Suzanne. I have one more presentation to go through, a very short 3-page PowerPoint for the tribes on the call. We will go over the intended benefit to tribes implementing leasing regulations. Number 1 is economic development, a streamlined leasing process. This may significantly reduce the time to execute and approve leases compared to existing BIA processes. It also is timely execution of leases may encourage potential lessees to invest and develop in tribal communities. The second bullet is tribal land management. Tribes may enact regulations that are tailored to the unique needs of the tribe's community, for example, housing, and Suzanne just covered that in her presentation. She also just covered this, access to 25 CFR Part 162. If a tribe with leasing regulations under the HEARTH Act believes a particular lease would be better supported under 25 CFR Part 162, the lease may be submitted for BIA review and secretarial approval under the CFR. Leases approved under Part 162 and any amendments, assignments, etc., will remain subject to Part 162 until lease termination or expiration. Adoption and implementation of tribal leasing regulations. These are factors for the tribes to consider. Number one is funding, added costs, or the diminishment of existing funds associated with undertaking full administration and management of leasing. Number two, the environmental review process. The tribes may request and the secretary may provide technical support for development of an environmental review process. However, there is no requirement for the BIA to perform environmental reviews after approval of the leasing regulations. Number three, existing and future leases. Leases already in place, executed and approved under 25 CFR 162 are still subject to BIA's leasing regulations. Approval of HEARTH Act regulations does not preclude tribes from electing secretarial approval processes under 25 CFR 162. Lease enforcement violations cancellations. Upon reasonable notice from the tribe, the secretary may enforce provisions of or cancel a lease. However, it is anticipated that tribes will manage all aspects of those leases approved under their tribal regulations. Last bullet, assertions of a tribe's non-compliance with its regulations. After exhausting tribal remedies, an interested party may petition the secretary to review a tribe's compliance with its own regulations. And the final page, the BIA's role after tribal leasing regulations are approved. Number one, lease review. Once the document is received at, let's say there was a HEARTH Act lease, residential, we'll just keep it simple. There's a HEARTH Act residential lease recently executed and approved by the tribe and the lessee. It gets sent over to the BIA. The BIA's, what the BIA does is listed right here under the lease review. They are simply because they're going to be putting it into TAMS unless the tribe has compacted or contracted all functions and TAMS. So if they have taken all the functions and TAMS, they will be encoding. But if they've only contracted and compacted the functions, then and not TAMS, then the lease still has to go to BIA for encoding and recording. So under the first point for the lease review, they're checking for those things under the three bullets. That the lease is executed and signed by all the parties, includes the term and payment compensation, that there is a sufficient legal description allowing recordation with LTRO, and that the lease gives approval authority to the tribe under its HEARTH Act code and not the secretary under the 162 regulations. So that's all they're doing. Okay, that's all they're doing. They get it into TAMS, it gets approved and it's sent to LTRO for recording. Under bullet number 2, approval, the secretary does not approve lease documents executed under the tribe's HEARTH Act leasing regulations. HEARTH Act lease documents are approved by tribal authority and according to the tribe's approved HEARTH Act leasing regulations. Last bullet, the recording process. Tribes are required to provide BIA with a copy of all lease documents, the lease, the amendment, the assignment, leasehold mortgages, renewals, and subleases, cancellations. They must provide those copies to the BIA. And the bullets 1 and 2 we just went through up above, but we are restating it again below. LTRO is responsible for recording lease documents. The BIA or tribe, as described in the bullet before, is responsible for submitting HEARTH Act leases to LTRO for recordation purposes after they've been entered into the TAM system. So this PowerPoint will be given to the attendees today, as we have done with all our other tribal outreach events that we've held. The other two documents that we did go over today are available on the website, which I put the link in the chat for, so you guys can access those documents on the website itself. I will send the PowerPoint out today for everyone, so that they have a copy of that to refer to. Other than that, I'm going to stop sharing my screen. I see that there are no questions. We thank you guys for attending today, and we wish you the happiest and safest during this holiday season. And thank you for attending.